Right, Mahima, thank you for joining us with those details. In other news now, the Delhi High Court has observed that contemplating a terrorist act, even without executing it, constitutes a terrorist act. The court said in its order, and I quote, the definition of a terrorist act under Section 15 of UAPA clearly includes the expressions with intent to strike terror by any other means of whatever nature to cause or likely to cause. Such an expression would not be linked only to an immediate act, but would even include acts which could be under contemplation for years together and may be given effect to after several years. Sambhav Sharma is joining us for more details on this story. Sambhav, take us through the ramifications of what the Delhi High Court has said in this observation.
Well, Delhi High Court bench led by Justice Prithviraj Singh has made very important observations under UAPA, wherein the Delhi High Court has said that even helping or some way helping in a clandestine manner or supporting a terrorist organization in itself is an act of terrorism. The message by the Delhi High Court is very clear, wherein Delhi High Court is emphasizing that even if one person or a party is supporting a terrorist organization, it will be constituted as an offense under the UAPA, stringent provisions of UAPA. Now, this particular case deals with one person, Rahman, who allegedly supported the Pakistan banned terrorist organization Lashkar-e-Taiba and other organizations, and a case was registered against him under UAPA, and he was convicted for 7 years for helping the terrorist organization. And in this case, the Delhi High Court has observed that even one person or a party is supporting a terrorist organization in itself is an act of terrorism under the Section 18 of UAPA Act. And accordingly, now what is this case? The case deals with this person Rahman allegedly helping or giving hideouts to the terrorists in his own house. So that was the case wherein NIA filed this case in 2015 and 2023. He was convicted for 7 years of imprisonment. And now that very important observations made by Delhi High Court in this matter. Uday.
All right. Rudra Vikram Singh, Advocate Supreme Court, also in fact joins us now live. Rudra Vikram Singh, what do you read into these observations made, and what do you believe their ramifications are?
See, the observation by the Honorable High Court led by Honorable Pratibha Singh, a very fine judge, very specifically she has stated in his judgment passed by two judges bench. If you read the Section 15 and Section 18 of the UAPA Act, UAPA that is Unlawful Activities Prevention Act, which was enacted to prevent such type of terrorist activities. And if you read the Section 15 of this Act, Section 15 clearly says that a terrorist act would be included if there is a person who threaten or likely to threaten. There are two words: threaten or likely to threaten the unity, integrity, security, and sovereignty of the India. So any act which will fall under this category, that will be come under the UAPA Act. And if Section 15 should be read with the Section 18 as well. Section 18, which says that any act, any preparation act, also any. If I read the Section 18, it says that whoever conspires, attempt, advocate, advise, any such act will be punished under the UAPA Act. So very rightly said by Honorable High Court about this UAPA Act, defining these two sections, Section 15 and Section 18 of UAPA Act, and very rightly convicting those accused.
All right. Let me in fact quickly also get in some more news now coming in. I appreciate you joining us, Rudra Vikram Singh, with your perspective. Also, Sambhav, who joined us earlier. Samajwadi Party delegation has visited Sambhal. They've handed over a cheque of 5 lakh rupees